to Spill. Case number 004. Who gets your Netflix password? And other questions you should be asking.
Hi, welcome back. I am your co-host, Megan Rogers, a paralegal, and I am here with the Sarah Young.
Oh, here we go. I am Sarah Young, attorney and co-host of this podcast. Maybe not your attorney, though. Just by listening to this podcast does not create an attorney-client relationship. This is for entertainment purposes only. Just keep that in mind.
Noted.
So, welcome back to Motion to Spill. And we're starting a series about estate planning because as we're getting ready to come into 2026, new year, new you, get your affairs in order. So, what we're going to talk about today is the terms of after use, exploring what happens to streaming accounts and things like that when you die.
Yeah, we might cover some basic things. So, there are basics that nobody tells you. What happens if you die without a will? Difference between wills, trusts, power of attorneys in plain English. The paralegal perspective on the most common, oh no, moments that family face. And our favorite, myth busting, my spouse automatically gets everything, right?
Yeah.
Among other topics.
So, will you do the quick attorney explanation of the difference between dying testate and intestate?
Sure. So first of all, we are situated geographically in North Carolina. I'm licensed in North Carolina only. So I might know the laws in other states, but I'm not speaking about them right now. So in North Carolina, there's testate and intestate succession. Testate with a will, intestate without a will. So if you have a will, then the person handling your estate is your executor, and you are the testator or the creator of the will. If you're a woman, you're the testatrix. If you're the executor and you're a man, you're the executor. If you're the woman, you're executrix. Or if you're two women, co-executrices. But anyway, that's just fun Latin stuff. But if you do not have a will, you die intestate, as they say, and you have an administrator of your estate, not an executor, and there's no gender, specificity, just the administrator. But a lot of people tell us, I can't tell you how many times, even at network events with other business owners, and they tell me, well, I don't really need a will anyway, because my spouse is going to get everything when I die, right?
And so that is all
true.
based on statutory laws.
Yes.
And in North Carolina, your spouse does not get everything
Automatically. Right. So here's a classic example we see as handling real estate closings, estate planning, and probate. So let's say a couple buys a house together. They're engaged, but they are not yet married. And the loan only goes into the husband or the male fiance's name. And the fiance is not on the loan, or even if she is on the loan, somehow her name does not get placed on the deed, right? So then something happens, he dies. Well, they're married now. So does the house automatically go to the spouse if he didn't have a will? So remember, her name is not on the title to the house. This is example one. Name's not on the house. He had no will. He has 3 kids from a previous relationship that he hasn't talked to in 15 years. Who gets the house?
Am I allowed to say?
Yeah.
Attorney Young has told me
this is
before.
not legal advice. It's for entertainment purposes only.
So she's only going to get 1/3.
Why is that?
Because his 3 children are going to share 2/3.
That's correct. So in North Carolina, if you have one child, regardless if it's with your current spouse or not, one biological child, and you die and you have a spouse, your spouse does not automatically get the homestead. They do not automatically get your primary residence where you guys live. She inherits a 50% interest only, and the one child gets the remaining 50%. If you have 2 or more children biologically and a spouse, you're married at the time, your spouse only inherits a 1/3 interest, and the kids share. There might be 2 kids, there might be 16 kids from 5 baby mamas. They are all going to split that 2/3, and that surviving spouse is going to have to deal with them because they will then have a majority ownership over her. So there are other ways, there are other protections and things around that, but that's a misconception.
So my house that I live in, I've been in it for 23 years. However, pretty much the exact scenario you were talking about, the previous owner, it was a barn. They converted it into a house.
Oh, barn dominium. Cool.
Yeah. So they were doing all the things. They were living in there together. All things were happy and jolly. And then he has a heart attack in the kitchen and dies. So because her name's not on anything, they were not married. He had 3 kids, 2 who do not live here. The 2 that do not live here wanted their
money.
Their money. They wanted their just rights.
Yeah.
And the 3rd who lives here, who knew the fiance, wanted her to have it. Well, the other 2 won, and because she was not on paper involved in any way, and the 2 kids who were the older 2 kids outvoted the younger kid who was here, they sold it to one of those we buy houses people.
For a fraction of
the profit, and the we buy houses people did not pay their mortgage on it. So bought the foreclosure.
Okay.
So we have let's say, I'm just making up numbers here. This is not true what I owe or anything like that. Mm-hmm. It was, let's say, a $275,000 house that we got for $100,000.
Yeah, that's like a nightmare scenario.
Yeah.
Especially, I mean, it's common now to cohabitate or to not, marry your partner, and that's okay. It's an individual choice. But keep in mind, if you don't have your affairs in order or you don't have an estate plan with that non-married partner or non-spouse partner, then they're not going to get anything. And, we represent estates on both sides of things, and it is messy. Even if you're married, if you acquire the house before you get married, your spouse is not automatically going to get it. And the kids can absolutely try and sell that house right out from under the spouse. Now, there are ways around that. So talk to an attorney if you're in this situation. I know a few.
Okay, excellent.
info@motiontospill.com. Anyway, even if it's not North Carolina, email me, and I have a list of referral partners cross country that we'd be happy to refer you to. But anyway, so right now let's talk about the situation with blended family. And you've got no will, and married couple. I've had this, one of the saddest situations I've ever handled was couple. I handled their closing. They were getting married, didn't get there, hadn't gotten there yet, and they were getting married, and then they're closing on their house. They're getting married the next week. Then they were going on their honeymoon. Tragic thing. We closed on the house. Everybody's happy. The husband was the only one on the deed. They had already moved in. They got married, and then somewhere between actually legal marriage and honeymoon, husband dies. Wife, had moved here from another state and had nobody else here. And his kids were all out of state, but were not on good terms with her. And so now, she's got all her stuff in this house, and she's just lost her new husband, and the kids own the house. So what's going to happen? Then you have to decide, well, in North Carolina, you can enforce a lifetime right in lieu of a spousal year's allowance. I'm not going to get into all those details, but basically you can ask the court to allow you to have a life estate in your own home that she had not even made the first mortgage payment on, but you better believe she's going to have to.
Yeah.
So, sad situation, kids trying to get her out, kids trying to sell the house, court has to get involved. It just gets so incredibly messy. But on the situation you brought up, Tim, where they're not married, there are no protections. It doesn't matter if it's same-sex couple, heterosexual couple, whatever. No protections for that person that is living in the house with you. If you've been together 10, 15, 20 years, it doesn't matter. There's no common law in North Carolina.
Yeah.
So that person can be evicted. In fact, I've handled cases where I've had to evict that person because I'm representing the children. Good, bad, or ugly. It's the law.
Yeah.
It's just really sad.
The
So
law is ugly.
it can be. How do you protect yourself?
So wouldn't that go into what's the difference between a will and a trust?
Well, it would. And I didn't want to get into this in this episode. That's like foreshadowing what's to come later.
Oh, okay.
But
So we'll
at bare
skip that.
minimum, don't buy a house with someone you are not married to unless your name is on that deed with right of survivorship. In any state, I'm not giving legal advice in any state other than North Carolina, and this is also not legal advice, but be on that deed with right of survivorship. What does that mean? Megan, tell us what that means.
So if you have, we'll say 2 people for your example here, when one person dies, the entire deed vests in the other person automatically
Right.
by operation of law.
Excellent. It's always like you are just studying this
I know.
for a very important test that you just passed.
Yes.
Anyway, congratulations.
Thank you.
Miss Certified Paralegal.
Because the other option, if your name is just on it, would be that you are tenants in common.
Yes, so we actually have estates like this, a messy one, in fact. And I always advise people at the closing table, hey, I can just put it Jane Doe and John Smith, unmarried. Leave it at that. But with the simple addition of as together as joint tenants with right of survivorship and not as tenants in common, you save yourself from having to deal with your deceased spouse or significant other's family. That house, you're making the payments on it. You know, why don't you deserve to get that house? You know, the 2 of you bought it together, needs to go to you. With that simple language, and a lot of attorneys don't advise you on that. So ask your closing attorney to put that language on that deed if you don't see it on there. I put it on there, but I take it off. Of course, the clients don't want that, and there have been instances. But the majority of the time, people just don't know. And if the attorney doesn't advise you, or you just don't know what you don't know. So that's the simplest, easiest way to make sure that house goes to you. And then if you buy it and then you later get married, you'll want to do what's called a tenancy by the entireties deed. And so in North Carolina and many states, there's what's called a tenancy. You can own property with your spouse as tenants by the entirety. And that means that you own all the property, and when that person dies, title in the property vests in the surviving spouse by operation of law. There are other benefits to that. In other words, let's say the 2 people are married, they're on there as tenants by the entirety. One of them gets a judgment against them. That judgment doesn't attach to their to the property owned by them together as a couple. It's just a statutory protection in North Carolina. It's one of the many advantages. But I always recommend, even if you're on there as joint tenants with right of survivorship before you get married, once you get married, do that tenancy by the entireties deed to clear title with your new names. And also for, creditor protection and estate planning reasons. So that's a simple tip there. But now let's get into the topic of
Terms of after use?
yeah. And we'll try and make this fun. It's very kind of heavy stuff. It's kind of boring, but it's needed, right?
Yes, absolutely.
So, we're going to try and decode some of the legalese behind everyday life, right? In this segment, we're going to call it terms of after use. Because what does happen to your Netflix password when you die? And I think it might be more complicated than your estate plan sometimes. But there are some simple ways to ensure, or simple ways to make it easier. We'll talk about that in a little bit. So go ahead, Megan.
So you have a will or maybe even a trust, and you've named an executor. But did anybody know how to log into your streaming accounts or your Facebook or your Apple iPhone?
Gmail, whatever. Yeah.
So Netflix and Amazon Prime, Apple TV, all of those platforms, none of them are designed to be inherited. And this has actually already been worked out in the court. So there's precedent on this.
So their user agreements treat your account like a non-transferable license. So when you die, technically, your access dies with you. All your photos, all your digital assets, your Amazon Prime account order history. Dear God.
You do not want your mom to see that?
I want that to die when I die. Absolutely. I might have to... I might have to make that as a caveat in my will. Digital executor accepts Amazon Prime. Anyway.
Access denied.
I like it. So anyway, at millions of people, right, share passwords across households, certainly among, like within your household. But when someone passes away, families just kind of quietly keep using the account. Sometimes.
That might be illegal.
I'm not commenting on that part. But the fine print, right? Netflix's terms of use say the accounts are for personal and non-commercial use, and only it may not be shared with individuals beyond your household. That part has been in the news. That's not too much of a surprise. But what happens when the account holder dies? Right? So Amazon, same. Apple, slightly better. They now have the digital legacy program. You guys probably saw that in a recent update on your iPhone. But you have to opt into it before you die. You can't leave a digital legacy in your will. It's too late. So most people don't.
So I did. I'm a good girl.
Good.
I set up my Apple legacy. But so can you leave your Netflix password and your Disney Plus password in your will?
Why would you do that? I'm just kidding. No, don't leave it in your will. They're non-transferable licenses. When you die, they expire with you. So that doesn't always stop people from fighting over them, even after you die. But
yeah, then you get into things like crypto wallets and people's Facebooks. And Instagram. We've even seen this with our estates. People getting mad about girlfriends or boyfriends logging in, and then it looks like their deceased parents online, and that makes them mad. And
so, what do you do about it? Enter the digital executor. So this is something, it can be a separate, it can, I've seen it as a separate document, but we always include it as a paragraph, kind of a catch-all paragraph in our will.
Yes.
That we draft. And so this is somebody you name in your will or estate plan to manage your digital assets, and it covers everything from, think about how exhaustive our list is. Netflix password, Dropbox password, email, cryptocurrency, digital wallet. I think it even might mention NFTs, which hopefully... Yes. Those won't be around still when I die.
Yeah. I have never understood the point or why anybody would spend that kind of money on something that you literally do not actually own.
Yeah, like a JPEG that Justin Bieber might have thought about creating. Someone created for him.
Yeah.
Anyway, crazy. So...
somebody just funged that non-fungible token.
Exactly. So this is a legally empowered role. And I started using this language in all my wills starting around 2019 when I had an estate with somebody with an account that's a brokerage account owned by one of the largest brokerage firms. There's like a top three, probably guess which one, but they wouldn't let the executor into this person's online account. because there was no digital executive language in the will. So I started
it
adding
kind
it.
of reminds you of like Charlie Snob, like that, like one of those. There's a play on the name.
Oh, I see what you're saying. Yes, it does rhyme with that. Charlie Snob. Huh, which one could that be? Or a move-in, stuffy. Anyway, we don't have time for that. Okay, so it's just
What?
anyway. Okay, so here's a sample clause. Just a quick clause. I mean, ours is a whole paragraph that takes up almost a whole page because we want to make sure it covers everything that we know about now and all the technology that could come up later. Because I guarantee you, if you would have told my 90-year-old grandmother that someday people are going to collect non-fungible tokens, she'd look at me and say, "Oh, what?"
Yeah.
So, there are assets that are going to be in existence now. I mean, I'm sorry, like 10 years from now that we can't even conceive of in 2025 when we're doing our estate plan. So
Yes.
try and cover things that could come up in the future. That's why I always tell people a lot of this probably doesn't apply, but it could maybe later in the future. So that's why we include this language in there. You pair that with a password manager or a secure inventory or just a list kept with your important papers that says, hey, my assets are here. We collect that as sort of an inventory in the intake process. And when we meet with people again to review their assets, we want them to refill out this inventory so that we can keep it updated for us on file in case when they die, the executor comes to us for help.
Yeah, because without it, the executor is going to be stuck guessing passwords and violating terms
let's be
of
real.
service and losing access to a lot of important documents and memories. So it's a problem.
And let's be real, Megan. When was the last time your mom gave you her bank login information?
Yeah, not never.
When was the last time your mom discussed where all her banks were with you?
Yeah, that is not something.
Yeah, I mean, and
about.
some of that's a generational thing. I know where my mom's stuff is, but that's because relationship's different. But it's not
And you are the Sarah.
right. Yeah, you can tell me anything. It's safe.
Here's $1.
I can't tell anyone. And I don't. I really don't. So, but anyway, that's a simple way. And if you have questions about that, please don't draft your own will. Please don't send me a draft of your will and ask me if it looks good, if you can get it notarized.
Yeah, don't do that.
But come to me, set up a Zoom, set up a consultation, or just go to another attorney that you trust.
So when you're updating your estate plan, don't just think about your house or your bank account. Think about your inbox, your Dropbox, your Amazon Prime order history, and your Netflix queue.
Your Google Chrome search history.
DuckDuckGo's your friend.
Absolutely. Anyway, give someone the keys to your digital assets before it's too late. And that's it for us for this episode of Motion to Spill. Quick reminder, while I am a lawyer, I may not be your lawyer. This podcast is designed to educate and entertain, not to provide legal advice for your personal situation. Every legal issue is unique, and good legal advice requires knowing all the specifics of your case, which I don't have from a podcast. If you need legal help with a legal matter, please consult with a qualified attorney in your jurisdiction who can give you personalized guidance. Thanks for listening, and remember, no attorney-client relationship is created by tuning in.
This is Motion to Spill. All rights are reserved. So this podcast is ours, not yours. We made it, we own it, and we copyrighted it. So don't steal our stuff, don't copy it, share it commercially, or don't try to pass it off as your own genius. If you want to use our content for something, just ask us, like a normal person. We might say yes, and we might say no, but at least you won't be breaking the law. Seriously though, unauthorized use of this content can get you in legal trouble, and no one wants that kind of drama. And I mean, come on, she's an attorney. Don't mess with her.